We will call the first case, People v. Johnson. And this is a 20-minute grant with an additional 5 minutes for Amicus Institute for Justice. You have 20 minutes. You may reserve time if you are able. And then we will call up Mr. House. Please proceed when you're ready.
Thank you. Chief Justice, Your Honors, and may it please the Court, Angeles Meneses, along with my co-counsel Stephen Helton and Matthew Monahan, represent Travis Johnson. Your Honors, the court cost statute, MCL 769-1K1B3, violates the separation of powers because it assigns the judicial branch the power to impose taxes, a power that belongs exclusively to the legislature. It also violates due process because it creates both the potential for bias and the objective risk of actual bias. The remedy here is to sever that provision of the statute and to vacate the court costs assessed to Mr. Johnson and Mr. Edwards. I'm open to the court's questions at any time. Your Honors, it is the judiciary's role to say what the law is in private disputes, but it's the legislature's to regulate public concerns and make law for the benefit and welfare of the state. It is the court's job to interpret and apply the laws, not to enact them and not to have to fundraise for their very own courts. Judges should remain nonpartisan. The fact that these costs are imposed at sentencing does not make them okay and does not make it within the penumbra of judicial discretion because costs are not individualized as one sentence would be. The court's expenses and their incentive to generate revenue by assessing costs have nothing to do with the facts of the case or the goals of criminal sentencing. It's just distracting to the judiciary, and it is a constitutionally assigned task for the legislature. Moreover, Your Honors, the court cost statute has no definite plan or minimal guidelines, no identifiable standards for judges to apply when determining when to order court costs at sentencing. The legislature is the one with the expertise and the constitutional authority to decide which defendants should pay costs or develop a workable standard for trial courts to apply when making this decision. Also, the statute places the categories of expenses to be included in the assessment of court costs in the sole discretion of the sentencing judge. That's provisions A through C. Provides a non-exclusive list of the types of expenses that might be assessed by a judge. But the examples are so broad that it's difficult to imagine any type of expense that a court could possibly incur that would not fall within those areas.
Would the constitutional infirmity be removed if instead of it being discretionary, it was just simply you must impose X dollars?
Your Honor, it would implicate the due process violation, and yes, that would change it a little bit because it would change whether judges have the choice to impose the cost or not and in what amount. And it does remove some of the problem, but that's not the only problem with the statute. It also is the fact that this is a revenue-generating statute rather than simply a user fee. It is
let's just stick to separation of powers. Why would it continue to be a separation of powers problem?
Your Honor, because it continues to be a revenue-generating statute, and taxing is solely for the legislature. It is not for the judiciary. It's a revenue-generating statute, and Cameron has already decided that this is a tax. And so taxing is within the strict power of the legislature and not the judiciary.
Okay, let's get to Cameron. I mean, they did say it was a tax. The statute actually refers to it as a cost. Isn't there something other than just taxes and fees? Aren't there things as costs that might be somewhere between taxes and fees? Perhaps we need to take another look at Cameron. Why do we have to buy this notion that it's either a tax or it's a fee? Can it be something else?
Your Honor, the court cost respectively cannot be anything but a tax. It is not a user fee. And the reason for that is not only the...
You're taking me down the tax or the fee. I'm saying it's not a tax, it's not a fee, it's something else. Can it be something else? Maybe we need to relook at Cameron. That's my question.
No, Your Honor, here it could not be something else. There are other financial penalties that are assessed as a matter of course during sentencing, for example, state minimum costs, crime victims' rights fees, things of that nature, but those all have discrete other purposes that have nothing to do with generating revenue for the courts.
So those would not be in jeopardy if we were to agree with your separation of powers argument?
Not in this particular case at this time, Your Honor.
I mean, because obviously we do have other non-penal fines and fees, and would we be having to look at the whole system if we were to agree with you?
Respectfully, Your Honor, that have to be handled on a case-by-case basis, but here with these facts, this is the only statutory provision that allows the courts to generate revenue for itself and gives the courts unfettered discretion to decide when to assess it and in how much, and that's why this is problematic.
So, and I understand that, but I am curious, I mean, are there problems do we have a separation of powers problem then for all sorts of non-penal fines and fees? I mean, if a fee is linked to something, a tether or participation in a problem-solving court, or that seems to me that's a fee with an actual, it's linked to a service. That seems to me to be okay. Do you agree with that?
I agree with that, Your Honor. Those things are all linked either maybe to the offense or the individual themselves. For instance, restitution is linked to the damages caused by a particular person in order to make the victim whole. All of these things have discrete purposes that have nothing to do with revenue generation, and so that makes those okay. But here, we have a statute that allows the courts to generate revenue for themselves, and that's what makes this problematic.
What about assessments for crime victim rights? What would that be?
That is a financial penalty that is attributed at sentencing. I don't know, I believe it's assessed in every case, and so the court doesn't really have discretion to decide to assess it or not, and it goes into a separate fund. So it doesn't have the same implications that the court cost statute has.
Okay, your answer takes me back to my first question to you. If we were to say that this has to be mandatory, like in Lockridge, we had mandatory sentencing guidelines and we cured the constitutional defect by saying it's no longer mandatory. Here we have a discretionary statute, and instead of saying discretionary, could it be solved by saying it is now a mandatory fee?
That could help to solve the due process problem, Your Honor, but not the separation of powers problem because...
I'm still having a hard time with separation of powers, but if it becomes mandatory and they have no choice but to do it, why is there still a separation of powers problem?
There is less of a separation of powers problem because you do remove that discretion, but the purpose of the statute is still to generate revenue, and that's one of the factors that Cameron looked at in deciding that this was a tax and not a user fee.
We're going in circles. Now you're
We
taking me
are.
to Cameron, and I'm still not convinced Cameron is right that we have only two choices, and that is taxes and fees.
Understood, Your Honor.
And I actually echo, I mean, I think Justice Zara raises an important point. I know in Durfee, that was a probate case where there was a percentage fee, I believe, that was charged on the estate, and that was found to be fine because it was a set amount that the legislature had set, and it wasn't discretionary. So I wonder, I mean, it seems like that's the point he's sort of getting at, and I'm wondering how would that be any different than Durfee?
Your Honor, respectfully, because Durfee is a user fee rather than a tax, because Durfee dealt with 5% tax on transfer of any property dealing with estate value. And so those people chose to enter the court system in order to have their estates managed. However, court costs is applied. You don't have a choice about entering into the court system. These are people who are accused and convicted of crimes, and it is not applied on those who are acquitted. And so they have no choice as to whether or not to be prosecuted or enter into the criminal justice system. And so that's where the distinguishing factor comes between user fee and tax here. Your Honors, this also creates a due process problem because it creates both the potential for bias and objective risk of actual bias. It creates at least the perception that trial courts assess arbitrarily high court costs out of institutional self-interest. The potential for bias does not come from the individual judges themselves. It comes from the framework of the statute itself. Costs are funneled back to the very courts that assess them, and that creates the appearance of bias. A fair tribunal requires both an absence of both actual bias and the
Good
public.
morning. What, in a real life kind of practical manner, what would the import be if the court were to rule in your favor? Isn't this really, in a lot of ways, the funding model that's used for most courts, especially district courts?
Yes, Your Honor, it currently is the funding model used for district and circuit courts, and a new system would have to be figured out by the legislature. It would be this court's job to decide whether this statute is unconstitutional, and it is, and to sever that provision of the statute. I do know that there are some bills currently working their way up through the legislature that can provide other potential fixes for this court cost provision, but also this provision is due to sunset in 2025 too, so another solution may very well have to be figured out regardless.
But in the interim, what would ultimately happen with the courts? I mean, I'm just trying to look at this from an institutional perspective.
The courts would have to, there would have to be another way of funding the courts, whether that would come from the state or other potential funds, I'm not exactly sure. But it would not be able to come from this unconstitutional provision where it is on the backs of criminal defendants like Mr. Johnson.
And other states do it differently, is that correct?
That's correct, Your Honor. And so this again is institutional bias. It is not reflective of actual bias in individual judges. A direct nexus between the money and the judge is not needed as existed in Toomey. that you only need the, quote, possible temptation for the average man as a judge not to hold the balance fairly, nice, clear, and true. It is a possible temptation for the average man as a judge not to hold the balance fairly. The remedy here is to sever that part of the statute and to reimburse both Mr. Johnson and Mr. Edwards for the court costs that they have paid so far. That is the remedy here, rather than plea withdrawal or resentencing, because the bias is most acute and the trial court's interests are directly opposed to Mr. Johnson and Mr. Edwards when court costs are imposed at the time of sentencing and not when the conviction is entered. If there are no questions at this time, I will reserve my remaining time for rebuttal.
Thank you. Mr. House?
Thank you, Your Honor. Joshua House for Amicus, the Institute for Justice, and I'll be addressing the due process question today. Federal courts have said a variety of circumstances can create an unconstitutional risk of or potential for bias. But I want to focus on one set of circumstances which comes from Caliste versus Cantrell, which was a Fifth Circuit case. And in Caliste, the Fifth Circuit held that Judge Cantrell violated due process when imposing bonds because a percentage of those bonds would go back to fund the New Orleans courts. That created an incentive to impose more and higher bonds on defendants. The same exact financial interest is present here. Michigan trial courts have complete discretion to impose court costs at sentencing, and those court costs go right back to pay for the court's facilities, supplies, and even salaries. That creates a financial interest to impose more costs on defendants, and that financial interest is present from the face of the statute itself. In some of the other cases that were spoken about in the briefing and that were spoken about today, there's an attenuated connection between the financial interest and the action taken by the court. But here, subsection 1B3 specifically says the point of imposing these costs is to pay for court salaries, supplies, and facilities. That means that defendants who come into court for sentencing see a court that has a statutorily mandated financial interest in imposing costs at their sentencing. Those defendants do not receive a neutral, detached court at their sentencing, but instead have a court that has a financial interest against them. And those defendants, therefore, do not receive due process.
Counsel, in theory, the district court judges all band together and decide, you know what, we're just not going to assess this, we're not going to do this anymore. And isn't the fact that, would you agree they could do that?
My understanding from the record is that the judges that do not generate enough revenue get pressured by their local funding units, or else their courts are moved to different buildings, are not sufficiently supported, and they can't do their jobs.
Right, but theoretically, they could just be like, I'm not doing it.
That's true. Theoretically, a judge could, and you see this in the other cases, right? The judges could always, as counsel noted, hold the balance clear and true between the guilt and the state, but the accused and the state. But that's not what that's not what the court looks at. The court looks at what is the appearance, what is the system, what does the system appear to, does it appear to have a potential for bias? And that objective criterion does not change based on the subjective will of a judge or multiple judges coming together to decide, well, we're going to be above that temptation. The fact remains that the temptation exists, and that's what's unconstitutional.
Okay, thank you.
So if the example that was given of this being mandatory and a set amount, would that avoid the due process?
I think what it would do is perhaps move the due process problem up the chain. It wouldn't, of course, be the judge. If the judge had no say, it wouldn't be the judge at sentencing who's violating due process. But it could be a variety of other government actors, whether the decision to charge or the decision to write a ticket in the first place or whatever. The local funding units could still very well have a due process problem if they're financially benefiting from these fines and fees or these costs. But that's obviously not the case here today, because we have the statute that only comes into effect at sentencing, and it only comes into effect because of the judge's discretion to impose those costs at sentencing. And of course, if the sentence violates due process, the correct remedy would be to reverse a sentence and then remand for further sentencing. We would ask this court to do what it would always do when a sentence violates due process and do exactly that.
Is there any distinction between a a defendant that pleads guilty versus one that is found guilty? Is there any distinction that we should make there?
Well, so there wouldn't be, especially in this case, because, again, the sentencing process comes after the plea. So people come in for sentencing, even once they've pleaded guilty, that sentencing, they still have a right to an unbiased adjudicator. And you see this, for instance, the Harper case out of the 11th Circuit was at the probation stage, post-sentencing. The Kane versus City of New Orleans case, the sister case to the one I mentioned before, was also about post-sentencing collection procedures. So defendants still deserve due process post-sentencing or post-conviction, even if they've pleaded guilty. Thank you.
Thank you.
Sorry, just a second. I'm just going to bring it up a little bit. Your Honors, and may it please the Court, Assistant Solicitor General Linus Banghart Lynn, on behalf of the people and the Alpena County Prosecuting Attorney. Also with me at council table is Michigan Solicitor General Ann Sherman. We respectfully request that this Court affirm the decision below. Your Honor, setting aside for a moment the remedy question, this Court has asked two constitutional questions in this case, and for each one we have sort of a procedural and substantive reason why this Court should reject the defendant's challenges. Turning first to the separation of powers issue, procedurally we would sort of reiterate that under principles of party presentation, it is the parties that should bring questions to the Court and not vice versa. Relatedly but distinctly, it's also better when the lower courts have had a chance to weigh in on a thing so that this Court isn't the first one to decide a question. This question wasn't raised in the Court of Appeals, it wasn't raised in the Circuit Court, and it wasn't raised by the defendant in this Court, and so that's a sort of a procedural reason. Substantively, we've also got we've got a long history in Michigan of courts imposing costs on convicted defendants with this Court's blessing, all the way back from N. Ray Johnson, coincidentally, Clark Johnson, which is roughly contemporaneous with Houseman, up through Wallace, up through...
Counsel, good morning.
Good morning.
Isn't that kind of the concern, though, that the defense is raising, that ultimately these court costs are basically being determined by the judge? They're not necessarily totally contributive to the actual offense that's being there. It does tend to be somewhat arbitrary. And in a way, the concern, I guess, would be, based off what defense is arguing, that in many situations, folks that can least afford are having to subsidize and pay for the court system to operate.
Yeah, I agree that the defendant and the amici have all kind of raised this point, and I believe that this is ultimately questioning sort of the wisdom of the system the legislature has created and not the constitutionality of it. I think that and the people don't have a position on whether this is the best system, whether it is the worst system, a good system. We have a position on whether it's a constitutional system. It doesn't offend due process, and it doesn't offend the separation of powers for the reasons that we've explained and that I'll sort of continue to explain. But to your question, I think that those are policy concerns that have been raised by the defendant and by the amici.
Are we to completely ignore our district court judges who have put forth lots of anecdotal stories about the pressure that's been put upon them? Is that something we're not permitted to consider, or?
Well, I would classify that as largely a policy concern. To the extent that it implicates due process, what I would say is that we don't have a single example of any judge ever succumbing to that pressure. And I think that what we need to do is we need to trust our judges to follow their oaths unless we have a really good reason to think that they're violating them. I would compare
But isn't that presuming that the standard is actual bias as opposed to implied bias or the appearance of bias? And so couldn't you have, in every case, that somebody is not actually biased in imposing these costs unfairly? But if the statute that authorizes them by, like every application is an application of implicit bias, isn't that the standard that we're going by, not actual bias, but implicit bias? And so isn't it a facial challenge?
It is a facial challenge, and it is implicit bias, but I think we need to look at what is the evidence that that bias exists. And if we don't have a single example of actual bias, I think that that is evidence that there's no.
Well, the evidence of implicit bias is the language of the statute, isn't it?
Uh,
That's saying that you're imposing the costs to fund the courts.
Right, but does that cause the judges, or could that reasonably cause the judges to betray their oaths? And the answer was in Dugan, and the answer is no. And this isn't distinguishable, right? I mean, there was that interest. If we accept the defendant's argument, then any pecuniary interest, however slight, however remote, however attenuated, is going to be a constitutional problem. But if that were true, then Dugan wouldn't have been decided the way that it was, because there was a pecuniary interest in Dugan, the same interest that we have here. And the U.S. Supreme Court said that's not a due process problem, right? Toomey is a due process problem where it goes right in his pocket. Caliste, at least according to the Fifth Circuit, is a due process problem where it goes, or at least a portion of it goes directly to the court's chambers, not to the judge, him or herself, right? But we don't have that here. We have it going into a fund, a lot of other sources going into that fund, and then out of that fund, the attenuation is so remote. And again, judges have a lot of temptations. I would compare this to elections, right? I could say, well, elections require campaigns. Campaigns require funding, contributions. There's a potential for bias. And look at Caperton, look what happened there. And so I could say, well, it's a due process violation for any elected judge to preside in a case because of these pressures. That's not the case. We trust elected judges to follow their oaths, and when there's an outlier case like Caperton, $3 million to buy a Supreme Court justice, then we reverse that case. We don't say all elected judges have a bias. It's the same thing here. It's the same thing as in Dugan. Right, all judges, yes, there is pressure that comes on them, and I don't think we should completely ignore it, in your words, Justice Welch. I think that, and I especially don't think the legislature should ignore it. Again, I'm not here to endorse any particular legislative plan, but I do think that obviously this is something the legislature needs to consider, whether we keep this, whether we scrap it.
I'm listening to your argument. It seems to me you're essentially arguing, well, it's okay because there's no evidence of actual bias. Am I missing something in the translation here?
No, there's no evidence of implicit bias, and I think that.
Well, what about the Trial Court Funding Commission's conclusions?
I'm not sure specifically.
They said that it creates a perceived conflict of interest between a judge's impartiality and the obligation to use the courts to generate revenue.
I mean, I guess I would say perceived who is doing the perceiving in that case? I don't perceive it, and I'm not sure who is perceiving it under that study. But I wouldn't perceive it. I guess
the commission.
The commission is perceiving it. And again, they don't like this system. And I'm not trying to accuse anybody of anything, but I understand. There's nothing wrong with an amicus saying, this system affects us in a way we don't like, and we hope that you overturn it because of the impact it's having on us. But that in and of itself isn't a constitutional argument necessarily, right? And there's nothing wrong with an amicus saying that. I've written amicus briefs that say that as well. But the constitutional argument here is separation of powers and due process. And we don't have problems with those under long-established, nearly 100-year-old, or in the separation of powers question, more than 100-year-old case law.
Can we focus for a minute on what the pressure is on the judge? I think I talked about this a little bit the last time we were here. Don't we have to keep in mind that there's a sort of a baseline requirement, constitutional requirement of adequate funding for the courts? So the local funding unit is constitutionally required to provide adequate funding to the court. Is that an accurate statement?
Yeah, I agree with that, yes.
So this notion that the judge is going to be thrown out to hold court in a barn, or that the court will be closed and that we won't have courts anymore, and all these other things that are being bandied about in this case, that's all ludicrous, right?
I think it's ludicrous under the current system. I mean, I think if the defendant prevails.
Well, but like you, I'm not endorsing or saying this is the best system, but the point is, and this is why it's hard to take the district judges seriously, the pressure is on them so that they'll have a little bit nicer court. They might have a little nicer courtroom or chair or something. But it's not about having an adequate courtroom to perform the important service that courts are supposed to provide every day in courts throughout the nation, right?
I agree with that, yes.
So I just think it's important to keep in mind, I went through this the last time, to the extent that judges feel pressure that they either have to raise this money or they can't function, those are judges who apparently don't know the law, right? So if the district judges wrote in their briefs that judges feel like I either have to raise these onerous funds or else I won't be able to function as a judge anymore, those are people who don't understand how the system works.
Yeah, I think that's correct, and I think that ties back into Justice Welch's question about can't these judges.
Which, by the way, I know that there are judges who want a nicer courtroom, and it may provide some incentive for that, and the judges who yield to that pressure are judges who should be not looked upon with favor. So the realities of the situation are what they are, but I just think we have to start with the baseline of what kind of pressure these judges are complaining about. It's also sort of goes through the whole system. I mean, there used to be a time, this stopped with COVID, but where police officers would write a lot of tickets to generate revenue for their municipality. Isn't that a thing that used to happen in Michigan?
I believe
And
so.
they had ticket quotas and so on and so forth. So, there's a lot more that goes with the local funding model that we have in Michigan. And if we need to change that, or we should change that, that's something for the legislature. But anyways, I just think it's important to make sure we understand when the judges are complaining about pressure being put on them, they have legal rights, and judges and courts have filed cases when they haven't been provided with adequate funding.
Thank you. I agree with all of that, and I appreciate it. Thank you.
Counsel, I'd love to turn back to the separation of powers argument. I think you would agree sentencing is more about punishment and looking at, potentially ways to help the victim and restitution. Is that a fair way to characterize?
Sentencing serves a number of goals, and those are some of the main ones that you've mentioned. I
Yeah,
agree.
the statute specifically references trial court salaries and operating expenses. I'm trying to figure out how that fits under the sentencing power.
Oh, I think it fits nicely along with a number of other sort of statutory provisions that are kind of adjacent to 769.1K, which allow reimbursements for emergency services, costs for prosecution, costs to secure the defendant's attendance. I think that it would be best to analogize this to a restitution that is a sort of a societal restitution. So we have a restitution statute and we have a constitutional right to restitution that are for the victim. But I think that 1KB13 and these other subsections that I've mentioned can be thought of as restitution for society for the costs that the defendant imposes.
For the cost to operate the court system.
In part, yes.
The third branch of government.
Yes, indeed.
Right.
And I think that, the legislature has to fund the courts, and the question is this a legitimate way to do it? As I think the legislature has helpfully pointed out in their amicus brief, Oklahoma has said yes, Texas has said yes, Maine and Florida, Illinois. This is pretty common, and as the court in Caliste pointed out, they said this doesn't imperil typical funding schemes. Caperton said, this is an extreme situation, right? We're not saying, if Caperton practically implied that if the guy had given $1,000 to the judge, it probably wouldn't have been a due process violation. So the notion that any, however slight pecuniary interest is a due process problem, I'm not comfortable with, going up against someone who gave $1,000 to the judge necessarily, but I've probably done it, and I'll probably continue to do it. I don't know. This is beyond what I know about. But the point is that what we really need is something more direct or more extreme, and not something remote and attenuated like Dugan. I've strayed from the separation of powers kind of into due process, and I'm sorry about that.
Thank you.
Getting back to, just looking at my time, I do want to talk a little bit about remedy. I wasn't originally planning to, but I do want to respond to sort of the amicus's point on remedy.
What a dangerous argument you make on the remedy.
Well, I'm hoping that you don't have to listen to any of this. But I just want to be clear that we don't think a resentencing makes any sense here. And a resentencing, I just want to emphasize to the court that resentencing is not a cost-free affair. There's a lot of costs involved in resentencings. If this court finds any error with the imposition of costs, then you can simply amend the judgment of sentence and refund the costs. All of the sort of everything that happens with resentencing would not be necessary, and so I would disagree with amicus on that point. So I just wanted to put that out there before I ran out of time, because it's not in the briefs. Just kind of looking at my notes here, obviously any questions will be.
Wouldn't if we found that this was unconstitutional, wouldn't it imperil the conviction itself?
I believe that it would, and I think that that's another point where I disagree with the amicus and also the defendant. The defendant has not crafted this as an argument that this only applies at sentencing, as sort of amicus described it. This has been crafted as not only do judges have an incentive to sort of ramp up the cost, but they have an incentive to convict in the first place, because if you don't convict, you get zero costs at all, right? And so that is the thrust of it, and in the original application for leave to appeal, the defendant says, well, no judge can preside in Michigan as long as 1KB13 is on the books. And so it does imperil the conviction. Now, this particular defendant has waived that particular remedy with respect to himself, but a holding that Judge Mack was biased, inherently biased because of the existence of 1K1B3, it would be sort of a tremendous holding for the future cases, and obviously this court is deciding all those future cases. So we would say that, as we said in our last round of briefing, that Mr. Johnson himself is only entitled to sort of the cancellation of the court costs because he's waived a greater remedy, but the holding that no judge in Michigan can preside fairly in any criminal case is a much more significant holding than $1,200 for Mr. Johnson. I would disagree with defense counsel when she says that this is something that the legislature, I think there was a suggestion that the legislature can sort of assess costs to convicted defendants. Sort of logistically, that's not in the legislature's view. I mean, you can imagine a defendant being convicted and then the court sort of refers the matter to the legislature and they're going to vote on the court costs to be imposed. That's not how it should work. That ties into the separation of powers question. With criminal sentencing, the legislature sets the policy and sets the framework and then delegates to the courts to carry it out, an individualized determination for each defendant based on the circumstances. And revenue raising, just like not only this subsection but other subsections, that's a legitimate thing that the legislature can delegate to the courts as part of the court's criminal sentencing power.
But isn't it sort of giving a, not that I want to like diminish the third branch's powers, but isn't that sort of giving a blank check to the courts to determine funding? I'm just wondering how this differs from the Houseman case. I mean, they seem pretty similar to me.
Well, I think that it's great to look at the language in Houseman that this court specifically said. The Houseman did not say courts can't impose taxes, courts can't collect taxes, courts can't assess taxes. The Houseman said that the sending out of surveyors or other persons to make examination or surveys to re-levy taxes in place of invalid ones.
But wasn't it they were determining the amount? Wasn't that the issue? The surveyors were determining the amount.
They were redetermining the amount after the court had held that the amount that the executive branch initially determined was the correct amount. The court then holds it invalid, and then the legislature said, okay, now to redetermine the amount, you, the court, have to make the new finding. And that,
But wasn't the court making, wasn't that the problem?
I think
that was supposed to be the executive branch's function, and the court was doing that.
Right, exactly. That was supposed to be the executive branch's function.
How is this any different? The court are making the determination as to the amount.
Right, but they're doing it as part of criminal sentencing, right? There was no criminal sentencing in Houseman. Criminal sentencing is very much the province of the judiciary, very much the province of the trial courts. So the legislature says, here's the sentencing range, here's the sentencing max, and then the court says, well, here's the sentence, the prison sentence. And the court says, well, here's the max fine, and the court says, well, here's the exact fine, or maybe there's no fine, right? And the legislature says, here are the various costs, many costs besides the one that's at issue here, and then the court's the one that actually imposes it. And so it is all part of the delegated criminal sentencing. With Houseman, it was basically like I think sort of a sui generis kind of thing where the ability to levy the tax in the first place was properly put with the executive branch, And then the legislature wanted the courts to re-levy the tax after finding it invalid, when it just makes sense for the court to send it back to the drain commissioner, say you did it wrong, do it again and do it right. That's sort of the familiar remedy when the executive branch does something wrong. The court says, you did it wrong, go back and do it again. And what was weird in Houseman and wrong in Houseman was the court said, you did it wrong, now we're going to do it instead. And that was the problem in Houseman. It didn't have anything to do with a categorical ban on assessment of taxes or raising of revenue by the courts. It had to do with sort of this very odd scheme where the executive levies the tax in the first instance and the judiciary levies it in the second instance. And that's why 10 years later, this court in In Ray Johnson said the common practice and the better practice in criminal cases is for courts to determine the amount of costs and impose it. And then about 35 years later in Wallace, same thing. Now again, the separation of powers wasn't raised, but this court then blessed in both of those cases, and later in Saginaw Public Schools and in Barber, although not under the facts of Barber, and all the way up until Cameron, this court has repeatedly blessed that courts can do that. Thank you, Your Honors. We respectfully request affirmance.
Thank you.
Thank you, Your Honors. Just a few brief points in rebuttal. The point was made by the Attorney General that there's no evidence of any single judge that has succumbed to the supposed pressure that is created by this statute. You don't need that kind of actual proof. You do not need actual bias. You do not need, as the Court of Appeals said, a direct nexus between the money that's assessed and the judge in particular. You simply need that possibility, that presence of temptation for the average man as a judge. It is true, as Judge Viviano said, that we should expect more of our judges. We should expect that they know that there are other remedies available to them rather than simply hiking up court costs if they want, quote, a little bit of a nicer court. But that's not all that money goes towards. This money goes to the very running and efficiency of the courts. It goes towards paying staff. It goes towards keeping the lights on, et cetera, et cetera. And so a judge shouldn't have any of that in mind when imposing sentence on an individual, when sending somebody to prison, when imposing other related costs and fees that have to do with the offense and the offender themselves. None of that should be crossing their mind when imposing sentence, and that's created by the very framework of the statute itself. It creates that temptation which Caperton and Ward and Toomey and Dugan have held is what the standard is to consider when there is a constitutional violation. Also, the Attorney General makes a big point of Dugan versus Ohio, claiming that case is on all fours with this case. It is not. The judicial officer in Dugan did not have a dual role. They did not in the executive and the judiciary, and so that problem was not arising. Also,
Can we go back to your first point? If the majority of cases are pled, talk to me about how what you're saying as far as the judge thinking at sentencing about costs. I guess I'm having a difficulty drawing that connection at that point in time where, there's requirements of what that sentencing looks like. Where does the cost piece come in where the bias is?
Respectfully, Chief Justice, whether someone pleads guilty or is convicted by trial doesn't really factor into that because the bias happens directly at sentencing. And so when the judge is imposing financial penalties that are relevant to sentencing, for example, restitution was one example provided by the Attorney General, that is strictly defined as the loss that was suffered by the victim. That is individualized to that particular individual and the offense or offenses they've committed. State minimum costs, crime victims' rights fees. But then we have this outlier that has nothing to do with the individual. It has nothing to do with the facts of their case. It has nothing to do with the facts that they've committed. It has only to do with how much money the court has spent in running its cases the previous year. It's not individualized to each individual person. And so the court is thinking—
But that wouldn't cure it, would it? I mean, if a judge put on the record during sentencing, that the costs were lower because of the nature of the offense, or they were higher because of the nature of the offense, and they did individualize it, that wouldn't cure the issue for you, would it?
No, it would not, Your Honor.
Okay.
But here we have an even bigger problem when those costs are not related at all to the offense or the individual themselves. The statute makes very clear that these are related to the running and the efficiency of the courts. It provides the courts with wide discretion to decide what costs are necessary versus not in running their courts, and how much money they may need to assess in each individual case. And so their minds are not, there's the temptation for their minds to be elsewhere than on the sentence and on the individual. That creates the temptation to be thinking of the fundraising needs of the courts. And again, that's not to say that there are individual judges who are specifically doing this, who are acting outside of their roles as judges, but the point is that the statute creates that temptation, the framework of the statute itself, and that's where the problem arises here.
Well, why doesn't it infect the convictions themselves? I mean, if the judges are revenue raising, that's their goal or their temptation, wouldn't they also be incentive to have the largest number of convictions possible in the highest percentage of cases? The
No,
judge
Your
would have a
Honor.
real disincentive to have acquittals, right? Or to dismiss cases or suppress evidence, because there'd be a huge incentive to have as many convictions as possible, to have this wonderful opportunity to raise revenue at sentencing.
Your Honor, that point is understood, but that it is not only judges who decide whether or not someone is convicted. In Mr. Johnson's case, yes, it was, because he pled no contest and the judge accepted that plea.
It could be a jury trial, but the judge still has to make evidentiary rulings and might have to rule on whether a case should be bound over for trial or whether evidence should be suppressed. Wouldn't this claim of bias that you're making, implicit bias, travel all the way to and infect every one of those decisions?
No, Your Honor, because the bias is most acute and the trial court's interests are most diametrically opposed to that individual at the time of sentencing, not at the time of conviction. And so it's the time of imposition of costs when the court has to consider its fundraising needs, its revenue generating needs when imposing those costs.
So when the motion to suppress, the judge doesn't care about keeping the lights on at that stage of a case. The judge only thinks about the funding of the court and so forth and keeping the lights on at sentencing? That's a little odd, isn't it?
No, Your Honor, because when at sentencing, the court has a convicted individual, whether that be by jury trial, bench trial, or plea, in front of them, and then has a decision to decide if to impose costs or not, and in what amount. And in doing so, has to consider the revenue needs of its own court. And that, in and of itself, the framework of the statute creates that temptation. We're not to say that there are, we don't provide anecdotal evidence of individual judges that do so. I understand that the Michigan District Judges Association does. But the point is that it's the framework of the statute that creates that temptation. That's all you need under the law. You do not need any evidence of any actual bias by judges or any, motivation on their parts to convict or make certain rulings in court. It is solely about when the bias is most acute and when the court's interest is
I'm
most.
not familiar with this doctrine of most acute bias. Bias is okay when it's more diffuse, but when it's most acute, it's not okay? Is this a legal doctrine?
Yes, Your Honor, it is in case, in Ward and in Caperton as well. When the bias occurs, when it is most acute, and when the interests are most opposed, that lends itself to what remedy
If
should
a
be.
defendant thought a judge was a revenue raiser and couldn't rule impartially on their motion to suppress, they wouldn't have a very good argument?
Well, Your Honor, that would go more towards an as-applied challenge if such a thing were to be presented to this court.
No, it would be the same facial challenge you're making today. That's the point, isn't it? If the statute does what you say, the question is, aren't you proving too much? Doesn't your argument prove too much? If we go along with it?
No, Your Honor, respectfully, because of the framework of the statute, the proper remedy here is to invalidate that part of the statute because that's what will cure the constitutional violation here. It will not be to overturn a conviction or to examine the judge's rulings. It's to invalidate that part of the statute so that judges do not have that temptation to revenue generate when they're imposing court costs in their courtroom. Thank you.
Okay.
Thank you. The case will be submitted.